Hello friends, today in this session we are going to discuss the case of Mr. Gautam Kundu versus State of West Bengal. Let us first understand this case briefly. The case of Gautam Kundu versus State of West Bengal pertains to Section 112 of the Indian Evidence Act and Section 125 of the Criminal Procedure Code, which relate to the legitimacy of a child and the right of maintenance. In this case, the appellant Gautam Kundu challenged the maintenance order passed in favor of his wife and child, claiming that the child was not his biological offspring. In support of this claim, he requested a blood test. The trial court and the High Court rejected this request, stating that according to Section 112 of the Indian Evidence Act, if a child is born during a valid marriage, the child is presumed to be the legitimate offspring of the husband, unless it is conclusively proven that there was no possibility of sexual relations between the husband and wife at the relevant time. The Supreme Court upheld this view and observed that a blood test only suggests probabilities and is not sufficient to rebut the legal presumption under Section 112. The court further clarified that no individual can be compelled to undergo a blood test, and refusal to undergo such a test does not necessarily lead to an adverse inference. Thus, the court concluded that the appellant's demand for a blood test was baseless and was merely an attempt to avoid the responsibility of paying maintenance. Consequently, the appeal was dismissed. Now, let us study this case in detail. Answer: Petitioner Mr. Gautam Kundu versus Respondent State of West Bengal. Reference AIR 1993 SC 2295. Subject of the case: this case pertains to Sections 112 of the Indian Evidence Act and Section 125 of the Indian Penal Code relating to the legitimacy of a child and the right to maintenance. The dispute concerns the determination of the father's responsibilities and the child's rights. Facts of the case: the petitioner married the second respondent on January 16, 1990, according to Hindu Rights and Customs. From April 5, 1990 to May 10, 1990, the second respondent went to her parental home to prepare for her higher secondary examination. Until her departure, they lived together at the petitioner's residence. In April 1990, the second respondent became pregnant. Upon learning of the pregnancy, the petitioner and his family pressured her to abort, which she refused. During this time, she was subjected to both mental and physical harassment. In October 1990, she went to her parental home for the Durga Puja and gave birth to a daughter on January 3, 1991. Trial Court: the second respondent filed a petition under Section 125 of the CRPC before the Chief Judicial Magistrates Court, Alipur, claiming maintenance for herself and her daughter. The petition was registered as miscellaneous case number 143 of 1991. On August 14, 1991, the court issued an ex parte order granting rupees 300 per month for the wife and rupees 200 per month for the child. The petitioner filed a revision petition in the High Court against this order, which is still under consideration. Subsequently, the petitioner filed another application in criminal miscellaneous case number 143 requesting blood group tests for the second respondent and the child, arguing that the child was not biological his and therefore he should not be liable for maintenance. This application was rejected on two grounds. First, there are other legal remedies available under the Indian Evidence Act to establish or disprove paternity. Second, it is an established legal principle that medical tests such as blood group tests cannot conclusively determine paternity. High Court: the petitioner filed a revision petition before the High Court against the order rejecting the blood test request. The High Court dismissed the petition, stating that under Section 112 of the Indian Evidence Act, a child born during a valid marriage is presumed to be the child of the husband unless it is definitively proven that there was no possibility of physical relations between the husband and wife at the time of conception. The court clarified that blood tests can only suggest possibilities but are not sufficient to override the legal presumption under Section 112 Supreme Court. The decision was rendered by the Supreme Court on April 22, 1992 in Criminal Appeal number 443 of 1993 challenging the Calcutta High Court's order. The petitioner argued that the only way to refute paternity was through a blood test and that considering advancements in medical science the High Court's decision was unreasonable. The Supreme Court examined the legal system of the countries like England, the USA and Italy and reviewed various judgments of the different high courts. The court emphasized that foreign laws cannot be applied to the Indian context without careful consideration. It also noted that consent for a blood test is mandatory, otherwise it would violate an individual's personal liberty. In this case, neither party consented to a blood test and it was unclear whether a guardian could consent on behalf of a minor. The Supreme Court also stated that there was no illegality in refusing a blood test and that if a party refuses to take the test, the court can only draw an adverse inference. However, it acknowledged that blood tests could be a useful tool in resolving paternity disputes and could be accepted as circumstantial evidence by the courts. Focusing on Section 112 of the Indian Evidence Act, the court established that if a child is born during a valid marriage, it is conclusive proof of the paternity unless it is proven that physical relations between the husband and wife were impossible at the time of conception. Based on these considerations, the Supreme Court concluded that the request for a blood test was unfounded and aimed solely at avoiding maintenance payments. Therefore, it upheld the order of the Additional Chief Judicial Magistrate Alipur and dismissed the appeal. Additionally, the Supreme Court allowed the second respondent to receive the maintenance amount without any security in response to her criminal miscellaneous petition number 2224 of 1993. Thus, the petitioner's appeals were rejected. Legal principle laid down. The Supreme Court established the legal principles in this case. First, Indian courts cannot order a blood test. If any party requests such a test, it should not be accepted. Second, to refuse the presumption under Section 112 of the Evidence Act, the husband must first establish a strong prima facie case showing that it was impossible for the wife to have been with him at the relevant time. Third, no individual can be compelled to provide a sample for a blood test, and if a person refuses, no adverse inference can be drawn against them. Fourth, Indian courts cannot order blood tests like those in England as they do not have the authority under either the CRPC or the Indian Evidence Act to do so. Please watch full video, share and subscribe to the channel. Thank you.